Once you've decided to create a trust in order to help save on taxes and avoid probate court, the question might arise, do I want a revocable or irrevocable trust? To explain the differences between these two types of trusts, we're fortunate to have today with us Kern Singh, managing partner and a founding partner of Singh Law Firm, which has offices in both Northern and Southern California. Mr. Singh, who started his law career in the San Francisco District Attorney's Office, has been running his own private estate planning legal practice for more than a decade. Of note, Kern is also a member of IFA's National Referral Network of Estate Planning Attorneys. Hi, Kern. Thanks for joining us today.
Hi, Murray. Thank you so much for having me here today. I appreciate it.
Let's start with why someone might consider creating a trust, whether it's irrevocable or revocable.
Great question. So you definitely want to always start out at the revocable side, right? Irrevocable trusts are set up for completely different purposes. So it's not one or the other. The first layer of the cake when it comes to your estate planning, if you have no documents in place, is evaluating whether you have a probate triggering estate. And if you do, then you need to set up the revocable trust. Why? Well, if you don't have a revocable trust set up, you have your assets in your name and you're able to freely sell and buy and open accounts, spend money, invest money, and no third party is telling you what you can or can't do. And that money is yours. You can spend it on yourself. And so you need the revocable trust because with that, we maintain the same relationship between you and your assets. Once you have the trust set up and your assets are funded into that revocable trust, nothing changes. You're still able to buy, sell, invest, spend the money on yourself, whatever you want to do. You have that freedom. This is your money. There's no taxation issues for you, and you haven't gifted the asset away like you would in an irrevocable trust. So the first layer of the cake for estate planning is setting up your revocable trust. Mark Zuckerberg, Bill Gates, Warren Buffett, these individuals all absolutely have a revocable trust set up. Now, irrevocable trusts are set up for completely different purposes. Now, if a client has an estate tax issue, which means that their net worth, their estate value federally, now if you're in California, the state of California does not have an estate tax regimen. There's no taxes here upon death. But federally, we do. So if you're lucky enough living in California to have a net worth above the federal threshold, which is your federal exemption amount, then anything above that threshold would be taxed at a tax rate of 40%, which is what we call your estate tax.
So that's where you would start thinking about irrevocable trust, correct?
Correct. Yeah. So if you're married, it's 13 million per person, 26 total. If you're an individual, it's a little shy of 13 mil. Now, this number is set to stay this way until 2026. It's going to sunset back down to 6 million per person in 2026. So if you're an individual in 2026, 6 million. If you're married in 2026, 12 million. But let's go ahead and see where Congress is at that point, because they could very well change it. Who's in office at that time? Is it a Republican or a Democrat? But that's, something that we'll have to cross that bridge come 2026. But for now, just focusing on those numbers. Now, if you do have an estate that's valued above the federal threshold, then we would consider setting up some form of an irrevocable trust, okay? And there's various variations of them. They serve different purposes. We're going to be looking at taking a deep dive and looking at the asset that needs to be transferred into the irrevocable trust for you. Is it stock in a privately held company? Is it shares of a publicly traded company? What are we looking for? So now there's a huge dissection plan that we have to do here for the client. And it's a big lift, but it's a lot of fun. But not everyone's going to need an irrevocable trust. You literally, Murray, have to think about it this way. If you're going to set up an irrevocable trust for your beneficiaries, and you're going to fund it, you're going to fund it with an asset. And once that asset's transferred over, you can't touch that asset for your lifetime. It's not yours. Any money it produces, if it's an income producing asset, it's not yours. It's going to the beneficiaries. So you have to be willing to walk away from that asset. That's how you get the benefit that the irrevocable trust provide to you. So again, it's a bridge that you have to cross after a pretty decent evaluation on what it is that you're trying to accomplish.
What about, I know some attorneys say that if you're young, just create an irrevocable trust now because your assets are going to grow. Does that make any sense?
No, yeah, that just makes zero sense, because the question I have here is that if I'm looking at that client who's the young client, and let's just say they're anywhere from 20 to 22 to 30, okay, maybe they finished college, they got a great job, or they're somewhere in their 30s or 40s for that matter. what's the purpose of setting up the irrevocable trust? If they're thinking, and that advice was given to that individual, set up that irrevocable trust. You're young, your assets are going to grow over time, transfer your home into that irrevocable trust, transfer your bank accounts into it. Well, that young individual can never use those assets for themselves. They can't live in that house. They're deriving a direct benefit if they live in that house now, right? Secondly, if that house is not paid off, the lender is going to call the loan because they're saying, hey, you transferred it to some other entity that you have no control over because it's irrevocable. We're calling the loan. So your asset has to be paid off. We have to look at gift tax implications, evaluating whether you're going to hit the annual gift exemption amounts, which you absolutely will when you typically set up an irrevocable trust because you're transferring significant assets. And so again, in this situation with those facts, I would say that's a horrible decision. And now flipping the switch there, if this young individual had the house, we set up a revocable trust for them. And let's say this client is at a startup company, and that startup company is going to go through rounds of funding and the share values are going to exponentially grow after that round of funding. Then yeah, we can set up an irrevocable trust for that individual, whether it's a GRAT or some form of a GSD trust for them or a minors trust. And they would transfer their shares in because their shares might be worth 10 cents right now. And after funding, they might be worth $10 per share. So that appreciation and growth happens outside of their estate because we transferred it at 10 cents a share. So again, this is a big balance we need to take. But again, when you say, hey, this young guy was given advice to set up an irrevocable trust instead of a revocable, I think that's bad advice.
Okay. And again, irrevocable and revocable can be used to complement one another. It doesn't have to be one or the other, correct?
That's correct. Yeah, you're not going to be doing one. Well, let's step back. You're going to be doing one absolutely no matter what, which is your revocable trust. Now, whether you need an irrevocable trust is going to depend on your facts, whether you have assets that require an irrevocable trust, you decide whether you want to set it up or not. But it's definitely, you look at the facts in that situation.
Okay. And I assume that you recommend to your clients that they talk not only to yourselves, a professional estate planning lawyer, but also a CPA, correct?
Absolutely. Yeah. Definitely when a client is high net worth, and we're talking about, potential estate taxes, we'll usually get their CPA and financial advisors involved. So, a big thing that's going to happen come 2026, Murray, is that if those numbers do come down, there's going to be a significant amount of individuals in California who are going to be affected by the estate tax. So some of them, even though they might say, hey, look, I don't feel wealthy, but I have an estate that's worth 11 million bucks or 12 million or 13 million, which is plausible in California because of real estate values and whatnot. But just stepping on that is that irrevocable life insurance trusts are going to be a huge component for individuals. If the exemptions do drop down to those lower thresholds, that's something that mostly everyone is going to have to look at if their net worths are above those federal thresholds, is that will be definite stepping stone into the irrevocable trust world, I would say for sure.
Okay. Well, thank you for your time again today, Kern.
My pleasure, Murray. Thank you so much for having me. It was an honor. I truly appreciate it.
You betcha.